Okay. It's a little after 10. We usually pretty punctual, so let's get started. All right. Okay, let's go ahead and get started. Matt, you want to open this in prayer? What number are you?
26. Michael Pruitt is having a hard day. Everybody bow your head. Dear Heavenly Father, thank you for letting us gather here today. Let us hear the business of the state. Let us we won't make any votes, but let us hear some good things that we can make some better decisions in the future. In your name we pray. Amen.
Thank you. Okay, just to give a little background, we've got some media guests from Voyage Pictures doing a documentary, so we welcome them. Because he was not here, but congratulations and welcome to Judge Chairman Vinson. Congratulations on the appointment from Governor Kemp. And he got right to work and appointed Bobby Potter as chair of the advisory council. So congratulations and welcome. And I think that's our the big changes. So we all know why we're here to discuss the worker who has I guess fallen through the cracks in the workers' comp insurance. So we're going to discuss a draft that started with and came from the advisory council who worked with Sean Marie. And again, I thank her every committee meeting, but I'm going to do it again. She is brilliant in figuring this stuff out and has worked with not only the advisory council, but folks from the ad hoc committee. Everybody who has contacted me or her or Bobby has had an opportunity to work with her to get their input. So the first draft, because I didn't want to feel like we sent something out and then pulled the rug out from under you. So we're going to look at a draft, but don't get too excited and too wrapped up because we got 2 more drafts coming your way. Because like I said, we've tried to include everyone's input, but I can tell you they were very slight changes. In fact, Sean Marie was gracious enough. One of the handouts we're going to give you is going to highlight the differences between the initial draft and then the 2 subsequent drafts. So with that, the one that was emailed out to everyone, LC 364884, is what we're going to start. And we're going to ask Chairman Bobby Potter to come to the table or the podium, which one you'd rather have. Dealer's choice. Okay. All right. So I'm going to let you walk through it. And then we've also, Brian, our policy analyst, has been hard at work on this. He's got a sign-up sheet that should be floating around. Got it right here. Did anybody not sign? Okay, so if you send it back up there. All right, so anybody who would like to speak is welcome to do so. I think I am going to hold the other parts once we get through the drafts. And again, this is a working draft. We're not voting on anything today or next week. We're trying to get to the end of a process that we can work with. All right, so with that, Chairman Bobby, take us through 364884.
Thank you, Mr. Chairman. So a couple of preliminary comments about that. At y'all's August 26th meeting, House Bill 397 was the topic. There were many concerns raised.
Bobby, hold on, because he's saying I may have What number do you have in front of you?
I got a bunch.
What
of
LC?
I've got 4884, and I've got 4891, and I've got 4892.
All right, most of the committee has 4884. All right, let's go with that. Let's start there and then we'll go through the progression.
4884.
Yep, since that's what the committee has.
Perfect. That's what I had until
Okay.
about
All right,
5 minutes
sorry.
ago. So the meeting on August 26th dealt with PEO client relationship and a potential of a workers' compensation gap. That's where it started. The general view, as I recall that hearing, was that House Bill 397 as presented would exacerbate the gap and not solve it. The PEO view, without speaking for the PEO folks who are here, but their PEO view, as I recall it, was at that point, they were sort of being unfairly put upon because of a given case that had been decided by the appellate division of the State Board of Workers' Compensation. So in some sense, 397 was maybe a reaction to that. There were several drafts that were in the mix then. I know of at least 4. Some came through Legislative Council through Sean Marie's story. Some did not. There was an ad hoc committee that had been designated and I was designated to be on it, but to my knowledge, that ad hoc committee has not yet met. At that last committee hearing, I sort of volunteered the advisory council to look at this if the ad hoc committee had not solved it or if this committee had not, to attempt to craft a solution that would meet the goals that had been set out by Chairman Werkheiser. And I'd sent a variety of those drafts to 2 committees within the advisory council, the licensure committee and the legislative committee. That bunch worked at Jekyll on a 2-day meeting, and upon adjournment of that meeting, I had indicated we would keep talking because there was no PEO engagement at that time. There was no PEO member at that Jekyll meeting. So they did not have input into that, and that we would keep working in November. Then I got the note that Chairman Werkheiser had called this meeting. So I called him immediately after that about what was the goal and where we were, and indicated to him then, which I'll indicate to you, that 4884 was the working paper, but it was a work in progress. It had not been finalized from the advisory council because there hadn't been any input from PEOs for starters, and that those folks that were looking at it still had to think through some aspects of it. So that's the draft apparently that you all have before you is 4884. My goal in that is the same goal expressed in August. It was the same goal expressed to the folks at Jekyll, and that would be to ensure as best as possible that there's coverage for employees when there is a PEO client relationship. Coverage in the world of workers' compensation. And I'm mindful when I say that I don't live in the PEO world. I am certain that PEOs provide a valued service to their clients. They do much more than just workers' compensation. And they exist and continue to grow. So that's got to be a good thing from one perspective. But I'm not certain of all the bells and whistles that a PEO provides. But it would appear to me, and it appeared to Legislative Council as we work through this process, that a PEO is different than an employee leasing company and is different than a temporary help staffing company. So with that in mind, I'll reference that again in a minute. I sent the drafts to Legislative Council that Sean Marie had not sent. And there were a couple of different ways to go about trying to solve this issue. And of a couple of those, that I sent to Sean Marie's story that she had not seen, she sent me back a note with about 10 items of questions and concerns on one of them. and 13 items of questions and concerns on another one. That led us to continue going down the 4884 path as opposed to an entirely different approach. Yesterday, I was on a call with two members of the WCCL that are listed as part of the ad hoc committee. Allie Kelly had reached out to me last week and indicated they had some concerns about 4884. So I spent the better part of an hour with David Moskowitz and Robert Bourne and Allie on a Zoom call, reviewing 4884 and what that language meant and what we were trying to solve. They had essentially one suggestion about that, and that I was fine with. I felt like the advisory council would be fine with it, and that it will be incorporated in one of these other drafts. That item that they referenced in that call yesterday, the same item had been referenced by somebody else that was at advisory council when he saw 4884 when it was circulated. That there needed to probably be one ad, and that same item was referenced by the chairman of the State Board of Workers' Compensation that's with you today, and their insurance folks had looked at the same thing and came to the same conclusion. So I think a lot of folks will be on a similar page when we reference that number change. But in regard to 4884, it might be easier just to go through that without reference because of the line numbers. So in line 14, that deletes the reference to employee leasing company as defined in code section 34.832 and replaces that with employer. The rationale for that was what I described, that it seemed to be three different entities. An employee leasing company is different than a PEO, is different than a temporary help agency. So this unties the PEO definition to employee leasing company and just references an employer that does the following things on lines 15, 16, and thereafter. On the second page at line 23 through 26 is the new language. And that indicates essentially if a PEO provides workers' compensation coverage for an employee of a client listed here as a co-employer, then they've got to provide it for all employees of that client co-employer. That's the intent of that language. So in the August hearing, one of the folks that testified said the problem was there's a carve out and it doesn't cover all employees. This attempts to address exactly that. So if the PEO provides coverage for an employee, it's not just the administrative staff where it's a low risk and they don't cover the folks that are up on the roof or climbing ladders. If they're going to provide it for an employee, they should provide it for all employees. So that is an effort to close that gap in that language. Sections 2 and 3 of the bill, I think, is Sean Marie language added because the definition had been detached from employee leasing. So that covers things that otherwise would have not been covered with a change in that definition. And in section 4, this is the section that provides immunity. It already exists in 3476D, but if immunity exists on the one hand, that is tort immunity from a lawsuit. If immunity exists for an entity, then they must be potentially liable for workers' compensation benefits on the other hand. They can't have kind of free immunity without having exposure. So this indicates that they have the exposure and they have the immunity. That's the nature of the trade-off of immunity for the provision of benefits. The concern raised yesterday, discussed again about an hour ago at lunch with a couple of folks, was in this last section, line 88 and 89. It references statutory employer, and that reads: a temporary health contracting firm or an employee leasing company shall be deemed to be the statutory employer for purposes of this chapter. The concern raised yesterday was the PEO isn't listed there. The PEO is described in the section above that from lines 80 to 87. I think that is the belt and part of belt and suspenders. I've got no objection to them being listed in the second part as well, to make it clear that they would be deemed to be a statutory employer. So that, walking in, I don't know, 20 minutes or so ago, was the bill that had been sent out to you all, that had been vetted through advisory council. And that was the path in which we felt we should go. The changes, and if you want, I'll just.
All right, Brian's going to hand out, and we've only got about 20 copies. So felt whoever can share a copy, because I know I want to get, especially the folks who are going to speak. So you're going to get, right, you're going to get 2 more drafts, and then you're going to get a document that Sean Marie Story was nice enough to show the differences, or maybe the better word would be the progression of how we got to the final draft. And for those who are unfamiliar with the process, if you look at the LC numbers in the upper right-hand corner, the higher they go, the later the draft. So Brian's going to hand those out. Again, they're not, the changes are more legal in nature than policy. But since I had sent out 4884, I thought it was fair to the committee to start with that, so that you're not discussing something you'd never seen.
Mr. Chairman, as soon as that gets handed out, I can walk through that.
Okay. Take one out. I've got 3 right here.
Who's A and B?
Okay.
Yours is
I've-
A.
I got them. Okay.
Does anybody else need a set? Are y'all good? Okay. Thank you. Sorry, that's a little unusual, but as Bobby expressed, this has been a very fluid, but again, as an attempt to include everybody that's has had an input. And as just mentioned, the ad hoc committee had not met, but it really served more of a, instead of a meeting, as we identified every potential player in the market. And then that committee was kind of the contact points to either get stuff to me, to Sean Marie, to the advisory council. So they have been thoroughly involved. They just haven't met physically. So with that, Bobby.
Okay, so you had 4884 before you. The next number is 4891 that you now, I think, have before you. There is, at least on my version, I assume on yours, some red ink changes. I see 3 of those, and they're not earth shaking. The first of those that I see is line 68 on page 5. I don't think there's anything before that, is there? Okay. Line 68 inserts a comma after 34,832. That was not in 4884. That is purely grammatical as I read it. There's 3 items that are listed. So generally in grammar, there should be commas after the first 2. That's why that's in, I think that's my take. It's why that's in there. The substantive change, to the extent it could be substantive, is at line 88. There were 2 items that were 2 entities that were listed before that would be deemed to be statutory employers. That was temporary help contracting firm or an employee leasing company. That was the language in 4884. 4891 adds the 3rd entity, the PEO, and that's inserted in between those 2. So it now includes temporary help contracting firm, professional employer organization, or an employee leasing company. Each of those shall be deemed to be. And the other change would be strike the and put in a statutory employer for the purposes of this chapter. In yesterday's conversation, there's probably 5 minutes or so about the difference between a and the, and whether it made a difference or not. Some folks thought it ought to be a. Sounded fine to me. So a it is, at least for this moment right now. So that's the difference in that one. And then the second one that you have before you, or maybe it's the third one, is LC 364892. The only additional difference, I believe, is on line 26, page 3. So if you go to 4884, line 26 ends with for all of the co-employers' employees. And a phrase has been added after that that reads, and shall be deemed to be the employer of all of the co-employers' employees for purposes of Chapter 9 of this title. And for purposes of Chapter 9, that is the requirement to provide workers' compensation benefits. So that may be belt and suspenders, but the indication from legal counsel is that this kind of nails this down fairly clearly, or not fairly clearly, very clearly. Fair enough?
Okay, we're going to hear from our attorney in legislative council who handles all the industry and labor issues, Sean Marie Story.
So just for clarification, the draft B, the LC 364892, does not contain the changes on in section 4 on page 5 at lines 90 and 91, where PEOs were added as statutory employers. So that is a difference.
And why did we do that?
You mean, why did you ask me to prepare this
Yeah.
draft?
Yeah, no, why did we do why did we take it off? Because you had a
So-
great reasoning for that.
Right. So as I recall, your rationale behind that is that draft B represents a different approach. And in draft B, instead of deeming the PEO to be a statutory employer on the same level as a temporary help contracting firm or employee leasing company, it instead goes into the part of the code where we are requiring that if the PEO provides workers' comp insurance for one employee of the co-employer, that has to provide it for all. And so therefore, it might not be a statutory employer at all if it doesn't provide any workers' comp insurance. And unlike a temporary help contracting firm or employee leasing company, at least as we understood it on the phone call, is that the PEO, the employees are not, by definition, the employees of the PEO. They are the employee of the co-employer. Whereas by definition, it appears that a temporary help contracting firm or employee leasing company, by definition, the employees are their employees and not the co-employer. And so it's a different approach so that we're not going into the part of the code that deals with statutory employment. That's my understanding hasn't really been fleshed out in case law yet.
I feel a lot smarter just listening to you. And as I understand it, part of the reason that we went down that road was it was brought up under federal code. There is language about who is controlling the employee, whereas a PEO may have no control over the employee. They're just providing workers' comp. And if they provide it for one employee, they must provide it for all of them. Is that a layman's way of saying it?
The only clarification I would make is that by definition, a PEO reserves a right of direction and control over the employees of the co-employer. And that is a part of the actual definition of what a PEO is. But later on in that statute, and I'm referring to Code Section 34-76, it does say that the co-employer of the PEO retains sufficient direction and control over the employees involved in that co-employment relationship.
Okay. With that, before we go to the speakers, do any of the committee members have a question? And we're also, if the folks online, I think we just Bonner, Representative Bonner, if you got a question, just use the hand raise or send us a message. Anyone else, if you've got a question, or we can wait until we hear from the speakers if there are none. Representative Park.
I've got one question, Mr. Potter and Sean Marie, in terms of the new language added on lines 27 and 28 in the most current version, LC 364892. By deeming the employer of all co-employers to be co-employers' employees, does that then make optional any other benefits a statutory employer would be required to provide, or is it simply limited to workers' compensation? Does that make sense?
So I'll try to answer that. Haven't seen this language for the first time about 10 minutes ago. I think this language is restricted to Chapter 9, which would be workers' compensation benefits. I don't think it does anything else relative to the PEO's requirement or obligations or ability to offer other services.
Okay.
The statutory employer catch-all that is in the bottom of 4884 and by your draft of 4881 that I referenced a minute ago that included the PEOs in that catch-all.
Mhm.
That is a case law definition. Statutory employer is not defined in the code, but it has been case law in the world of workers' compensation for 4 or 5 decades and is generally understood. And that is that circumstance where the immediate employer, oftentimes in a construction setting, does not have workers' compensation insurance. So it goes up the statutory food chain to whoever hired that immediate employer, which would be generally a contractor, and it may go up yet another level to the general contractor. Those entities are deemed to be the statutory employer of the folks below them where there's non-insurance coverage. That's in 34.9.8, and that has been in the law for a long time and has worked for the most part very well. It has differed some when leasing companies were created and temporary help staffing companies were created. And then this ripple when PEOs were created and what has occurred since then with PEOs. But they, as I understand it, were created 22 years ago in 1999. And the difference, and I may be going beyond your question, but the difference is I see it with those two employee leasing companies and temporary help folks. They have employees under their umbrella over here, and their client needs an employee or they need a human being to do some service for them. Let's just stay in the construction world because it's easier, but it could be in the office world. And they lease that employee over here. And the whole time they continue to be employees of the leasing company or the temporary help company. They're providing all of the benefits. They come over and do a service for that client, and the client pays this leasing company or temporary help company for that service. And that temporary help company pays their employee. The PEO, at least as I understand it, they kind of go over and they have all of the employees or some of the employees of the client company. And this is co-employer sort of legal fiction, but it's not employees of the PEO that they're sending over to the client. They go over and acquire the employees of the client and call them co-employees of that co-employer. That's what makes it difficult. And in this circumstance that was referenced at the August 26 hearing, when it's carved out and they just acquire some of them, the low risk administrative folks, but not the higher risk people that are out in the field, that creates the problem and the potential gap.
Thank you.
Yes, sir.
All right, if there's no other questions from the committee, in fairness to the PEOs, since they're playing defense on this, I'm gonna let them go last. So I'm gonna call on Ralph Perales from the GIWA, Georgia Injured Workers Association. Come on up, Ralph.
Thank you, Mr. Chairman and members of the committee. Appreciate the opportunity to address these issues with you. And I've been before you before, just in case you don't know me. I'm president of GIWA, Georgia Injured Workers Association, Advocates, I'm sorry. And I'm a practicing comp lawyer. I just was reviewing the latest version, 4892, a few minutes ago when you handed it out. So I'm gonna either make a fool out of myself, or I'm gonna have to reserve, my criticism for later until I'm able to digest all of this. One of the problems in trying to define this animal that we're dealing with, the PEO, is that things are blurred in the real world. These temp agencies, ELOs, employee leasing organizations, and PEOs kind of blend together. And you can start with a zebra and end up with a tiger. Now, y'all met Ken Thaxton last time, who was the lawyer for Mr. Robles in the Robles contracting case. Sorry, Robles versus Nicholson contracting case last time. He was going to be here to address you today. Unfortunately, he became, he's sick. So he asked me to sort of convey some of the concerns that he had. And of course, we were looking at version 4884. In his case that he's litigating now, he's got about 6 or 7 litigating against a PEO. A PEO created this temp agency whose employees were placed under the PEO. And the host company retains the labor from the temp agency. Now, follow that. What happens with this version that we have now? If the employee, if Mr. Robles, in that case, that's not the case that we're talking about. He's got 6 or 7 other cases. But if in that case, the PEO simply creates a temp agency between him and the customer, then he benefits from not providing workers' comp insurance, and he gets exclusive immunity in this case. Now, as I stated before, the PE industry has come up with a great business model. It's good for mid-sized, small, and even big companies. I mean, I've got nothing against them. My concern is with the bad actors in the industry. And there are bad actors in everything. The bad lawyers, bad doctors, good doctors. You know, we dealt with that in the opioid, crisis that we have. And there are bad actors in the PEO industry, and Mr. Thaxton is litigating against some of those right now. And in that case, if you pass this right now, particularly with subsection F on section 1, which says individuals who perform services for a temporary help contracting firm, as that term is defined under 34.846, shall not be considered employees of a professional employer organization. And yet that's exactly what that PEO is doing, is hiring those temp, putting them under the PEO, and then the temp agency goes out and does the work. So now we've created a problem. So I'm sorry if I'm sort of raining on your parade here about we thought we kind of corralled this animal, but unfortunately, bad actors are ahead of us. I mean, they really figure out how to, game the system. Another concern that I have with temporary help agencies, I've represented clients in workers' comp claims that work for temp agencies who got injured about 3 years into the job. 3 years assigned to the same place, doing the same job, working for the same temp agency, working for the same employer. Now, at some point in time, I mean, we got to figure out what does temporary mean. I mean, to me, temp agencies provide labor for 30 days or maybe seasonal labor, the Christmas holidays, maybe the summer, maybe 3 months, we need extra workers. Maybe a company gets a big contract and needs immediate, to help to staff up. But when you have workers that are working for a temp agency in the same assignment for 3 years, that sort of loses its meaning of what a temp agency. And that's what I mean by, in the real world, we're sort of mixing and we don't know where the line is. Now, I've read the statutes that define professional employment organizations, employee leasing organizations, and temp agencies. And, I can't really know I don't understand the difference between employee leasing companies and PEOs. And that's why initially in the statute that we have now in PEOs, it says that, as used in this code section, the term professional employer organization means an employee leasing company, because they do the same things that an employee leasing company, except that it has established a co-employment relationship. And to understand that, you got to go back to the 70s when we sort of came up with this idea of employee leasing organization. And back then, those companies basically follow what is called the fire and lease back model of business. So they would go to an employer and they say, fire all your employees, we'll lease them back. We'll hire them and lease them back to you. And so what you end up is basically the same company with the same people doing the same work, facing the same risks, having the same accident history, everything the same. Well, the insurance industry didn't like that, because what happened was they could not use the experience modifier when underwriting the policies now that employer had, because now we have a new employer, which is the leasing company. And so they were placing these employees back into the same things that they were doing before. They were writing policies, but the underwriting was not done, accurately because they could not use the experience modifier for that employer. So they started losing money. And from that frustration is where PEOs came out. Now, PEOs follow what is, they sort of left behind the, fire and lease back. And what they did was they used a co-employment business model, where now that employee has two employers, the co-employers. And the PEO traditionally handles all the administrative, legal aspects of labor laws, comply with wage and hour, payment of wages, overtime, reporting of taxes, unemployment, employee benefits, all those things that we do administratively. And then they let the employers, the co-employers, sort of, operate their business, directing and controlling those employees, right? Because if you ask a PEO how to lay concrete, as in the Robles case, they're going to look at you and say, I don't know. What safety measures should we take? Don't know, have no experience. How do you build a circuitry board? Don't know. Stamp concrete? Don't know. Fabricate a widget? Food processing? They don't know. They don't know how the daily operation of that business is conducted. So they can't direct or control that employee. And my concern with this new definition here is that in trying, in a good faith attempt to close that door that the Nicholson contracting, the Robles Nicholson contracting case opened, we're sort of closing that door and opening a window. Because under the definition, it says that a PEO is an employer that has established co-employment relationship with another employer, pays the wages of the employee of the employer, reserves the right of direction and control over the employee of the co-employer. So let me tell you what a bad actor is going to do. I'm going to leave that out of my service contract. I don't need to control or direct this employee because I don't know the first thing about what this company does, right? So I'm no longer a PEO. I put myself out of this. And on top of that, we're adding subsection F now that says an employee of a temp agency, a temporary health contracting firm, as that term is defined under 34.846, shall not be considered employees of a professional employer organization. So now I can point out and say, well, maybe I'm a temp agency, or maybe an employee leasing organization, company. And so my concern is that we have the escape hatch now, as Mr. Thaxter now is litigating. And if you pass this law, he's out of court. Because those employees of that temp agency that had no coverage, by the way, the temp agency had no workers' comp. So he's going after the PEO, who has all the employees of the temp agency. And that's exactly the argument they're saying. We can't be liable because he's an employee of a temp agency, really, even though the PEO is really the employer. And so, unfortunately, this is a very slippery animal. What we need to do is look at the footprint of tort immunity. Isn't that what we're after? The quid pro quo? Let's get tort immunity, and in exchange, we're going to cover. So wherever you find tort immunity, there's got to be workers' comp coverage, one or the other. So, I'd like to read this a little bit further. I mean, I know that there's been a lot of work put in this. I'm not suggesting that, we're leaving that on purpose, but, this issue is a little bit more complicated. To make matters worse, in some of the cases that I explained to you, I've had clients who work for temp agencies. I had a client that worked for a temp agency for about 1.5 years, close to 2 years in the assignment when she was injured. The temp agency had an office inside, it was a commercial bakery, inside the commercial bakery. My client went there to interview and get hired for the job, went to an office inside this facility, met with somebody, got hired for the job, went there every day for 1.5 to 2 years. Her payments were made by direct deposit, no stubs, right? And she gets injured, and I have to tell her, you don't work for the bakery company. You work for this entity over here that is, they call themselves a staffing company, a temp agency. So my client had no idea who was the true employer. And I found that many times when they just don't know. Had another case, and I want to tell you real events. I mean, we can play the what about this or the how about this, but best thing is actual life examples. Had also a client that was working for what she thought was a temp agency, a staffing company, got injured. When I'm investigating, I find the staffing company has no workers' comp. I keep investigating further and I find out that the individual behind this staffing company, those bad actors that I tell you about, had 16, I believe, maybe 20 staffing companies in the metro area. It was a large number. I can't remember where it was a few years back. And only one had workers' comp. And what he was doing, I suspect, I could never get to the bottom of it, but my client fired me because I couldn't get benefits started soon enough because I was trying to figure out, all these shell companies. And by the way, I think it's been about 2 or 3 years. And as far as I know, she still hasn't gotten benefits because, we get the notices of when benefits get started. Haven't seen that come through. I think what he was doing basically is, getting one company, put a few employees so that his premiums, comp would be low. And then he probably was spreading his labor over 16 companies, and then probably using that certificate of service to try to get jobs, and then they send somebody, the person, you work for a staffing company? Yes, I do. Now they don't bother to check if it's one or the other staffing company. You got 16. And so again, the point is, we have to be careful with the bad actors and what we do with this law that provides them with the ability to operate out there. I'm not concerned about the good employers, the one that, try to do things right, and there's most of them do. But every now and then, unfortunately, I tend to see a lot of the then, because as a lawyer, they tend to hire me when there's a problem. Nobody hires a lawyer when everything's going well. They're getting their benefits, they're doing all this stuff. Yeah, so I tend to see all these issues with some bad actors. To make matters more complicated, there's something out there that is called a labor broker. Somebody who just provides labor like a temp agency, but they don't call themselves temp agency. And they try to fall under the borough servant doctrine. I'm just providing you labor and, here's your problem. He's a borough servant. I mean, I have cases like that too, where they just sort of try to commingle all these entities. So my main concern with this is that we do not leave an open window so that somebody can say, I'm not a PEO.
Okay. Let's let some of the others, Bobby, you want to respond to any of those that perceived loopholes? Or I know Sean Marie, do you want to make a comment about that? All right, go ahead.
Sean is pointing at me. So globally, I would say we may not fix every problem in this universe. This is certainly an effort to do this. The language that's been added in your last draft, 4892, that deems employees of the PEO or the PEO to be an employer of all of the co-employers' employees for purposes of Chapter 9 of this title. That really borrows from existing law and leasing companies in 34.9.8, I think it is, or maybe it's 8.6. Let me see. (34.832) that says employees, the leased employees remain employees of the lessor, the leasing company. This is putting that same language which exists in the law right now for leasing companies in this PEO context. And I think that covers that gap. If, as Mr. Perales says, a bad actor says, well, I'm not a PEO because I don't do many of these items that are listed in the definition of PEO, then they are going to have to do something of value to have a client base in the first place. So I don't know that we solve everything. We're certainly trying to solve the issue before us. And I think its language probably comes pretty close to doing that.
Okay, thank you. Representative Carpenter.
I just wanted to make sure I'm not always the best at reading the tea leaves, but it seems to me like the attorneys and the insurance companies are finally on the same side with each other. Is that what?
We're close.
That's what I felt like that. So I just thought I'd make that rare occurrence
Okay.
made known.
So noted. Vice Chairman Kirby.
Thank you, Mr. Chairman. Mr. Potter, you can probably answer this and make sure I'm right off the top of my head without looking it up. Because all the staffing companies I work with have comp insurance, and I think under Georgia law, if they have 3 or more employees, you have to have workers' comp insurance. So that would keep them from all of a sudden saying they're a staffing service. Have I got that number right?
3 or more is correct.
Thank you.
Representative Park.
So I think my question was directed to Mr. Perales, but it sounded like your only concern was subsection F regarding the fact that if someone is considered or performing services for a temp firm, that they would not be considered an employee of a PEO. Other than that provision, are you otherwise okay with the effort to ensure that there are no loopholes or that?
Well, I'm a little concerned with the definition of a PEO that where it says reserves the right direction and control over the employees, because again, PEOs don't do that. I mean, when I hear from the PEO industry, but like I said, I mean, in the Robles case, that PEO probably didn't know the first thing about laying concrete.
But I think that's where the reserve the right comes in. They can give up that right. Is that not correct, Jean Marie?
Well,
His concern was about the reserve the right. The PEO not knowing or directing the employee because they don't have the knowledge. But the reserve the right is the escape hatch for that, correct?
The language that you're both referring to regarding reserve the right of direction and control, that is in the existing PEO statute definition currently.
the way I would read the statute, if I'm allowed, reserves the right means that I've reserved it for me under the contract. I have that right. I'm going to reserve it. That's the way I read the statute. Not that I may or may not have it, or is my option to have it, is reserved for me. I make the reservation, so that kind of concerns me, and I don't know if we need it.
Okay, well, let's hear from the PEOs. So John Walraven, tell us who you are and who you represent.
Good afternoon, Mr. Chairman, ladies and gentlemen on the committee. I'm John Walraven, and I represent NAPIO, the National Association of Professional Employer Organizations. Thank you again for convening this meeting today. I really want to start off, and I'm going to try to be really brief, by just briefly noting who is in this room. We have policymakers who are looking to deep dive into this issue and try to make sense of it all. We've got lawyers in the room, both sides. We've got business in the room. We've got the Board of Workers' Comp in the room. We've got basically every single player that could be part of this. I'm going to call it a case because we're really here because of one case. There's some others out there, but the only party to this whole mess who's not in the room was the employer of the man who had to stand in that concrete. He went to work that day, and his boss, who didn't buy workers' comp coverage, made him stand in that concrete, and it burned him from the shins all the way through his feet. So where is he? Nobody knows. He's enjoying the fruits of that labor. Didn't buy workers' comp coverage. Where is he? Does Georgia even care? Because we're in here right now trying to figure out who's going to be the deep pocket and take care of the fraud that was perpetuated against that man and against the people that I represent, because they didn't even know that that man existed the day that he stood in that concrete. So we're going to have today some folks that really understand this stuff come behind me and try to explain that workers' comp coverage. I mean, how can you as an actuary figure out what the risk is going to be if you're going to be required to cover somebody who you don't even know exists? Now, I've been back here listening. There is no difference between an employee leasing and a PEO. We've got some really old law in Georgia, and that's what the problem is. We had a bill in 2017. It almost got out of insurance committee. It was an omnibus bill that would have put real world definitions. But the former commissioner of insurance objected to one sentence in that bill and it killed it. So I'm going to explain. I used to work for the House myself. I spent 4 years as an employee of the State House. So I've done just like all y'all, and I've walked into the fiscal office. So let me explain in ways that we can all understand what this is. When you walk through that door and you go to see Sherry and you want to talk about either health or some other kind of benefit that you have, just imagine as you walk across the threshold of her door, now for the purposes that you're in there to discuss things, you're now Sherry's employee. That's co-employment. The PEO essentially is outsourcing HR. That's all it is. It's good for small businesses, medium businesses, even some large ones, but that's pretty much what it is you're outsourcing HR. So the law has created this dynamic called co-employment. When you walk across the door threshold to go see Sherry, you are now her employee. Why are you her employee? It's because she's only right now in what we've heard, direction and control of those benefits that she spends her day working in. Now, when you walk back out of her office and you step across the threshold, you're back to being an employee of the people who you represent. So that is co-employment, is that while you're in the PEO's office, you're their employee for the purposes of enrolling in their group health plan. That's the reason that a guy who has one employee can have an employee benefit package that is only offered at like UPS. That's the kind of service delivery that PEOs bring. So the case that we're all here about, the poor guy who had to stand in the concrete, again, the PEO who ended up paying over $500,000 to settle his case, never even, the day that they went to work, they had no idea that person existed. But under this proposal, that PEO is going to now be on the hook to insure these people they don't know exist. So the guy who is probably sitting at the beach right now, and he's the one who made that guy stand in the concrete, and he pocketed that money that he should have used to buy the workers' comp coverage. He ain't in the room. But we're all in here now trying to figure out what we're going to do the next time this happens. And there will be a next time, because right now, Georgia doesn't care. Georgia's not prosecuting this stuff. Georgia's not going after these bad actors. Instead, we've got a lot of money in this room trying to solve this problem. We could enforce whatever statutes we have on the books to root out this fraud, or we can come in here and try to figure out who should be the deep pocket that covers that fraud. I'd prefer that Georgia actually try to figure out what, go after the real problem instead of trying to figure out some way to cover this up. Behind me will come Georgia's president of the PEOs. His name is Lane Davlin. He's been in this for over 3 decades. He's going to be able to help y'all understand where the rubber meets the road. And Blake Sowers is going to appear virtually. He's with a workers' comp insurance company, and he'll explain a lot better than I can. Really, I can't even explain what he's going to explain, but it's got to do with the chain of liability. And I understood it when he explained it to me, and I'm glad that he's going to appear here to explain it to you. Now, if anybody's got any questions for me, great. If not, I'll let Lane come talk.
Since we're already at the hour period, we're gonna hear from these. Just everybody realize we're gonna be back. This is a draft. So don't anybody get too excited, but since we're already at the hour mark and they've waited this long, let's hear from them.
Thank you.
All right, Lane.
Thank you so much. Hi, I'm Lane Devlin. I'm with Co-Advantage. I'm the president of NAPIO, which is the National Association of Professional Employers. A professional employer groups a lot of small groups together to buy things like workers' compensation, benefits, HR. We manage the payroll, the tax deposits, all the things that a small and medium and some large employers aren't set up to really deal with. But we deal with clients that hire other companies to come do work. This rule would make us liable for employees that the client's vendor was not covering anyway. We had no way of knowing it. They didn't get an I-9. They didn't do the E-Verify on them. They didn't, get tax forms or anything else to make them a new hire in any way. So, putting everything on a professional employer is not really the solution. We still have that vendor or the sub who didn't buy comp. He's got over 3 employees. He's required to do so, and he's decided to not. It makes him more competitive than others because if he's not having to pay that, then he may be able to do it for a lower cost. We're very much in the compliance industry. So we help our clients try to stay in compliance with all the new rules, with all the new laws related to COVID, any EPLI issues, and anything else that, the small employers are not equipped to handle. The mandates, providing that we cover everybody would actually make the professional employer a provider of last resort. We would only get the clients that had no other place to go. And that's not really our model. It would really force our industry to exit the state. There is no carrier that would want to take on the risk that they can underwrite. If it's an unknown, just an unlimited risk, there is no carrier who will ever write it. Questions?
So I appreciate you coming in today, and educating us on it, on this whole process. But your last statement kind of rang a bell with me, and I'm not against you. I'm for you. But at the same time, we're asking insurance companies, other people that don't have PEOs, their insurance companies to be liable for these type incidents, correct? But you're saying we shouldn't ask you to be liable. Is that a fair assessment of your statement?
Well, no. I mean, we want to be liable for the risks we have, the risks we know about, the risks we are collecting premium and paying to the carrier. The risks that we don't know about, how should we be liable for those? We're not collecting any money. The carriers are not collecting any dollars on it. So our carriers would have an unfair disadvantage covering a professional employer compared to the standard carriers that actually can come in and audit the client and can collect the premiums that they didn't pay directly to the carrier.
I got you. So that's actually the piece. I'm glad you hit on that piece. So it's the audit piece, right? Because what happens is at the end of the year, I do an audit, and then whoever I 1099, if I don't provide proof of workers' comp insurance, then they audit, then they catch that premium at the end, correct? And you don't have that capability.
Right. Under our model, we only, collect and charge on the data reported to us. And that's the wages, the hours, the gross amount commissions, whatever it is.
How do you collect? Do you collect any kind of 1099 data at all?
No.
Okay.
No, we don't actually process any 1099s through our professional employer at all.
Okay.
We only do W-2.
Fair enough. Thank you, sir.
So in reading the language, it does seem fair in that there is a conditional statement where if a PEO provides workers' comp, then it must do so for all of the co-employer's employees.
Right.
And so does that not provide some certainty in terms of any risk assessment in which you could then negotiate per contract with the employer in terms of ensuring that the employer is covered? And additional question, under current law, are employers able to have some employees covered under a PEO, but not others? Because ultimately the objective seems to be just to make sure all employees otherwise have workers' comp.
Yeah, we actually require all employees to either be on it or off of it. You know, you actually cannot select groups. The only way you actually can discriminate against certain groups or carve them out is if they're set up as a separate entity and not actually reported to us. And we don't mind covering the co-employees. The problem is the ones that aren't employees. They're not employees of the client. There may be employees of the sub, or maybe they're 1099s of the sub. So nobody's actually made them any type of a standard employee by forms, by reporting, by anything.
But wouldn't this language otherwise essentially and do what the current practice is? Because I don't think it would retroactively apply to any 1099s that otherwise then become employees of an employer, would it?
Right. No, I mean, any 1099, you know, who became a W-2, they actually would actually be, you know, covered from the day that they're actually reported. And it could either be, they could fax in the information, they could call in the information, they could do it through a portal. I mean, you know, there's all kinds of ways of doing that, because normally you actually are going to ask a new employee to fill out their forms, to get their tax forms, confirm that they're eligible to even work. And by doing that, you know, you have then made them a W-2 standard employee. The issue is still the ones that we don't know about. The ones that were never going to be reported to us anyway. We're never going to be reported to the client anyway. That a sub says, I've got comp, but I don't have my certificate. You know, that is the ones to where nobody's collecting any money on, you know. So.
Okay, let's hear from Blake Sowers online.
Thank you. Just as a little introduction, I'm Blake Sowers with Sons Insurance Company. We are a monoline workers' comp carrier. We specialize in staffing and PEOs. We've been around since about 2005. We almost exclusively write staffing and PEOs. I've been with Sons about 3 years. I was the chief underwriting officer for the first 2.5 years, and now I'm the director of program development in charge of profitability for our large PEO clients. There is some language within the proposal that would cause some serious changes in underwriting of how we evaluate and underwrite risk. So one of my observations is, and seems because of this case, it's largely due to the construction industry. You don't see this problem in other industries. You don't see the uncovered employee. It just doesn't happen. There's no issues with the PEO model in industries other than construction. And the reason is because there's a lot of fraud in construction. There's a lot of uncovered employees. There's a lot of people that do not pay their workers' compensation coverage. There's a lot of interchange of labor where you go job site to job site to job site. So our PEOs and the PEO industry does a really good job of providing coverage for small and mid-sized contractors that sometimes deal in heavier risk. So if you ask an insurance company like us to write PEOs that do some construction, and you're saying that, hey, anybody that goes on a job site that could be uninsured now could have a backstop with your PEO client company just because they're on a job site, is basically what this legislation does. So when you already have mechanisms to prosecute fraud and do that, but you allow now a fraudulent actor like a staffing company the previous gentleman talked about that has 16 entities, only one has coverage, and they're putting people all over the state. Now, if that temporary staffing employee goes to a job site where there's a PEO, now that can be deemed an employer because they're on that job site working with a PEO client company and they have a backstop. So all you're doing, in my opinion, is two main things. Number one, PEO client companies have to comply with a lot of regulations and law. They sign employee applications, they do E-Verify, they do a lot of these things to make sure those employees are legal to work at the state. They're doing the right job, and all that provides a comfort level for us as a company, Sons Insurance, to underwrite that PEO risk. Is what you're doing is you're adding a lot of unknowns into that, where anybody could go to a job site and then be deemed an employee of the PEO client company because they're an uninsured subcontractor or they're temporary staff that has not filled out any of that paperwork. So if that happens, now the people that are complying with the law that have coverage are now being penalized at the benefit of the uncompliant people that do not provide workers' compensation to their employees. And I believe that's exactly what happened in this court case. The person that had direction and control of that employee who directed him to go stand in concrete did not have compensation, and it got then assigned to a PEO client company through the court system because they're looking for coverage somewhere, right? So what's going to happen is insurance companies like us that provide workers' compensation for PEOs will start eliminating construction, and which will push more people either into the assigned risk pool or to be uninsured in general because it'll be cost prohibitive. And it will raise costs for all construction in the industry because you're pulling people out of the voluntary market through the PEO and you're putting them into an assigned risk market, right? A market of last resort. So those are the unintended consequences. Is it'll be decreased underwriting appetite for Georgia businesses that work in high risk construction, specifically mom and pop, small and medium, which is really the bread and butter of the PEO industry because they're providing HR services, they're providing legal support, they're providing taxes in SUTA, the FICA food and SUTA, and helping a small employer be able to compete with other large construction companies. So if this causes the insurance company, the PEO, to be in the enforcement arm of fraud, they're ill-equipped to do it, like from an audit perspective and from a compliance perspective. And it never deals with a lot of the unintended consequences, like a lot of these people that are committing work comp fraud are also committing payroll tax fraud and things like that. And it allows that stuff to really be, hands off because, hey, the PEO will cover it when the PEO has a lot of liability that they're making sure their clients are operating the right way. So there's a lot of unintended consequences to adding, if anybody on a job site can be an employee, a covered employee of the PEO, when really it should be limited to just the co-employed employees. Sorry, I talk really fast. I apologize.
That's fine. Thank you, Michael. And we're going to hear from our final speaker, and then that's going to be it, because we're going to take all this. Sean Marie is busy taking notes. Bobby Potter's taking notes. Everybody on the ad hoc committee is either here in person or listening, or most of them are. We're taking all this input and we'll go back to the drawing board. So Michael, come on up. Introduce yourself and tell us who you're with.
Yes, thank you, Mr. Chairman and members of the committee. My name is Michael Kreider. I'm with the National Association of Professional Employer Organizations. I'll shorten it to NAPIO to save you all some breath and my breath. But yeah, look, I'm here from the national perspective, right? I just want to let you all know, looking at this, we've looked at Georgia. We'll take a look at this latest draft. But from the national perspective, these kinds of subs or these legislative drafts that shift or intend to shift the liability out of PEOs doesn't exist anywhere else in the country. It doesn't, and no other states have this that would make, basically, as Blake said, as Lane said, the PEO is the backstop. I mean, people are just going to start dumping everybody into a PEO and saying, well, there you go, they'll just cover them, right? And that, again, as Blake mentioned, perpetuate fraud, do all these things. So I don't want to bore you all. I really think that we need to focus on the things that could be fixed, right? Let's go after those fraudulent actors. Let's try to increase those types of, I don't know what we do, right? More fines, more penalties, or really increase the amount of people that can go to job site and really try to find, who has certificates of insurance, so on and so forth. The other thing I'll mention too is just, Mr. Walraven mentioned at the very beginning, Georgia's law with respect to employee leasing, professional employer organizations, temp staffing is old. It really is. And we have a model, NAPIO has a model. I'm happy to share that with you. It got, as John mentioned, pretty far. I think that will help with a lot of the issues, right? It will expand definitions. It will make licensing. There's a licensing or registration component. So that way, which PEOs are playing in the sandbox, right? You can go after and find them. There are a bunch of other things in our model act that go to address, really just various things, who's responsible for what under certain areas of the law, workers' comp, benefits, so on and so forth. So I would encourage to start there, not to continue down this path, right? But I think there's a couple things that this body could do, and we'd be happy to continue to help. But I just, this is not seen elsewhere, and I think it'd be bad Georgia policy and bad for the state and bad for the small employees and the PEOs, obviously.
All right, thank you.
Thank you.
Hold on, Mr. McLean might have a question for you.
Thank you, Mr. Chairman. And, I don't know if it's a question, but I just want to make a comment and a statement and a lot of things too. I heard what you're saying about the PEOs and no one wants to be responsible. No one wants to take blame, the employee is not here. But what about the worker? I mean, what about him? I mean, my question was this anywhere in the world? But you answered that, well, no other state has this. But the model that we have is not working. And I can understand that it's not being,
Yeah.
it's old. But what about the worker, the person that was injured? Where does he fit into this?
Yeah, absolutely. I mean, I appreciate the question. I think Lane could probably answer this better. I will attempt to do so. The PEO covers 100% of its employees, right? The co-employees that are under the CSA, the contract that we contract to go for that. The PEOs are usually, as Ms. Corral said, there are bad actors, but we don't see very many of them. PEOs are very clear in that if these employees are not under our CSA, you are responsible under Georgia law, existing Georgia law, like any other subcontractor, contractor, to obtain that workers' compensation. So it should be working right, but it's not. And that's not I truly don't think that's a result of there being a PEO. Let's say you take the PEO out, it's still going to happen, right? You're still going to have that gap, and it's going to have, as I mentioned, the vertical immunity. But you're just skipping all that and you're just going straight to the PEO now. So we are concerned with the worker as well. We are. If people maintain proper workers' comp coverage as they should.
Okay, we're going to
Could be nothing
end with
affects-
Sean Marie.
Sorry.
Sean Marie's going to be our final speaker since we're closing in on an hour and a half. Because again, we're not done. And then hopefully all this input, the model legislation, we look forward to seeing that in addition to everybody else's input, and we'll have you something else to look at. But let's hear from Sean Marie. Yeah. I thought you had your button pushed. Okay. All right. Yeah. Yeah, I don't want to infringe on anybody's evening. So if that's okay, I know several people had their buttons pushed, but with that, let's stand adjourned. Stay tuned. We will be here again. Yes. Yes. Every day, morning and night. No. But yes, we're going to meet again during special session. We are adjourned.